My name is David Sobel, and I'm a real estate and finance attorney serving in Michigan and in Ohio. Every week, I receive a few legal inquiries as they relate to real estate law, contracts, and financial disputes. And, I sort through these questions, what I believe to be the most interesting each week, and I provide my answer to the question here in this video. So this week's question comes from Megan H., who's a real estate investor out of Texas. And she writes that she owns property here in the metropolitan Detroit area. Good thing, Megan. And she writes in to say that she's selling her property in Waterford, Michigan. And Megan and the buyer are currently under a purchase agreement. And Megan says that they're scheduled to close on the purchase agreement before the end of this month. So what Megan has a concern on is that her buyer, she writes, has informed her that they're not going to be closing because the buyer is concerned about a issue with the roof. And according to Megan, her buyer has raised this concern long after the buyer has already inspected the property and has waived the inspection period, or what we call the inspection contingency. The buyer is now bringing this up days before the scheduled closing. So additionally, Megan's also saying that the buyer has agreed to take the property in as-is condition. So finally, Megan says that there's also a title issue that she still has to resolve before she can go to the closing. So based on these facts, Megan really just wants to know, what are her legal rights against the buyer if the buyer decides that they're not going to close as per the agreement? It's a great question, Megan. It happens quite often, believe it or not. And generally speaking, when a party does not close on a purchase agreement, and that purchase agreement is a legal contract, then there's really nothing more that a seller or buyer can do, whoever it is that's not closing, especially when there's no remaining contingencies for the parties to the agreement to close under the purchase agreement. Then the only thing that the parties can do is bring an action for what we call specific performance. And this is brought against the non-closing party, or what we call the breaching party, by the party who wishes to close. So specific performance is a legal remedy where the damaged buyer or the seller requests from a court to compel the breaching party to actually perform their obligation and complete the transactions. And courts can do this. They provide court orders that compel people to close. So because in property law, real estate is considered unique, therefore, money damages are not always the most adequate to compensate a party who wishes to complete a purchase agreement. So they're going to want instead that order that says you must sell or buy this piece of property. So Megan, if your buyer does not want to close and all of the contingencies in the case, in this case, the home inspection contingency is waived, then you could file an action to compel the sale, or you can file this action for specific performance. One side note, and I do want to mention that when Megan says that the buyer agreed to buy the property in as-is condition, or where is as-is, the buyers still have the right to actually inspect a property, even if they agree to take the property as is. So during the inspection contingency, what can happen is a buyer can actually do the inspection and reject the property just based upon their findings. So in Megan's case, since the buyer's time to object to any of the items that they found in the inspection has passed, the buyer really has no legal right further to assert why they're not going to close based on an inspection. So the roof, in Megan's case, the roof, for the reason being for the buyer not to close, is not an adequate excuse. But one more item, Megan, and that is that you said that you're still in the process of clearing up your own title issue before the closing. So it sounds like at this time, even if the buyer were prepared to close and Megan's not, before Megan makes any legal demands on the buyer to close, she too should actually make sure that she can actually close. So title issues can delay a closing beyond a closing date. And in this situation, Megan's buyer could actually walk away if that closing date has come and gone. So the buyer may not have any liability to Megan if Megan can't perform on her obligation, which is to provide clear title. So Megan's question is really a great illustration on how every transaction is different, every fact scenario is different, and therefore the legal solutions that an attorney can provide will change. And I hope you found this very helpful, Megan. For those viewers who are still watching, if you like the video, please care to share it with your friends and your family. You can also leave a review on what you like about it. And please feel free to write in the comment section other topics that you would like for us to discuss. It's very helpful. And if you wish to submit your own legal questions like Megan just did, you can also reach out to us. Just email us at team@provenresource.com. That would be great. The questions come really right to the paralegals, and they look through them, and then I look through them. And again, we sort through the best ones to go through for the week. Also, I want to let you know that I just released a new book. It's called Shady, How to Protect Yourself When Doing Business with Friends and Relatives. You can download this book for free by just going to our website, provenresource.com, and go to the resource section, click on the resource tab, and you'll be able to get the book there. You can download the book. You can also order the book online. Finally, I never assume that you need anything from me, but if you ever have a question related to real estate law in Ohio or Michigan, contract law, or financial disputes, please feel free to give me a call at 888-789-1715. Again, I'm David Sobel, and thanks very much for watching.